Hello friends, hope you are all doing well. Today I will discuss some very important case laws on Consumer Protection Act. I received few emails from my different viewers for this case laws discussion on important case laws on Consumer Protection Act, and so I am today doing this episode on Consumer Protection Act, various important case laws. In Manjit Singh versus National Insurance Company, Honorable Supreme Court, it was a case where the appellant purchased a second-hand truck under a hire purchase agreement. The truck was second-hand and it was purchased by obtaining loan. The vehicle was insured by the respondent insurance company. One day, when he was driving the truck, a passenger asked him to stop the truck and give him a lift. On the highway, when he was driving, someone asked for some lift and the driver stopped the car. When he stopped the truck, the passenger brutally assaulted the driver and fled with the vehicle. An FIR was lodged and the respondent finance company was intimated about the theft. However, the insurance company rejected the claim on the ground of breach of terms of the policy. Actually, truck is meant for carrying goods, not any person. The complainant approached the District Consumer Dispute Forum, State Commission and National Commission for compensation of his loss. All of them had rejected the case. So finally, the complainant, the truck owner, approached the Honorable Supreme Court. Now, this was the fact. This is the background of the case. What Supreme Court decided, what Supreme Court observed. The Supreme Court held that the appellant was not at all in fault. It can be considered as a breach of the policy when the truck driver was driving the truck on the highway. Someone asked for lift and he stopped the car. That is the violation of the policy, but no fundamental breach to bring the insurance company to an end and terminate the insurance policy. The two-judge bench of Supreme Court directed the respondent insurance company to pay 75% of the insured amount along with 9% interest per annum from the date of filing of the claim. The court also directed the insurance company to pay sum of rupees 1 lakh as compensation. Leave the compensation amount part. But here the interesting thing is the truck is meant for carrying goods. Someone on the highway asked for lift and the car driver stopped the truck. As soon as he stopped the truck, the person who asked for lift attacked the truck driver brutally and fled away with the truck. Insurance company rejected the claim. Starting from District Forum to National Commission, the claim of the truck driver has been rejected. But Supreme Court allowed his claim. Why? This is a breach of the policy, but not a fundamental breach to bring the insurance policy to an end and terminate the insurance policy. On this ground, Supreme Court allowed the claim. Though truck is meant for carrying goods, not people. In another case, the insurance company refused to compensate the respondent because of damage caused due to heavy rain during mentioned period. The vehicle was damaged due to heavy rain. The insurance company admittedly denied relief to the insured on the basis of one of the conditions of the policy, which stated that national insurance would not be liable for any loss or damage 12 months after the event of loss or damage to the insured. The insured filed a complaint with the National Commission under the provisions of the Consumer Protection Act. The National Commission held that the claim made by the insured is actionable. It also observed that the goods were insured at the time of incident and he asked for the claim next day. It rejected all the contentions urged by the national insurance and ordered the insurance company to pay an award of such and such amount. So in this case, there was damage caused due to heavy rain. The insurance company denied it. The National Commission held that the claim made by the insured is actionable despite the provision in the National Insurance policy. It also observed that the goods were insured at the time of incident and he asked for the claim next day. So the clause of 12 months doesn't arise here. Based on this ground, this claim was allowed under the Consumer Protection Act. The next one. Ashok Iron Works, a private company which manufactures iron, had applied for obtaining electricity from the state's power generation company, the Karnataka Power Transmission Corporation, for commencing its iron production. In spite of paying charges and obtaining confirmation for the supply of 1500 kVA energy in February 1991, the actual supply did not begin until 10 months later in November 1991. So he got the power supply after 10 months from the date of filing of the application for power supply. The legal argument by the KTPC, Power Supply Corporation, was that the complaint was not maintainable as the Consumer Protection Act 1986 excludes commercial supply of goods. As per the definition of consumer under Consumer Protection Act, those who are purchasing goods for their commercial use doesn't come under the purview of Consumer Protection Act, subject to some exceptions recently observed by the Honorable Supreme Court. So the Power Supply Corporation argued that the complaint made under Consumer Protection Act is not maintainable at all because it was an application for commercial supply. It also made an argument that the company is engaged in manufacturing iron and intended to use it for commercial consumption, which is excluded under the Act. So the company applied for commercial supply and the company will use or has been using the power for manufacturing iron and iron products. So it is commercial use. In this case, Supreme Court held that the General Clause Act that includes a private company within the purview of the definition of a person. It also held that the power supply of electricity by the KPTC to a consumer would be covered under section 210, being a service. Also, if the electric energy consumer is not provided to a consumer in time as is agreed upon, then under section 21G, then there can be a case for deficiency of service. Therefore, the clause stating supply of goods for commercial purpose would not be allowed. The Supreme Court sent back the case to the district forum for retrial on this ground. So, what is the basic observation of the Supreme Court in this matter? Number one, Supreme Court explained that under General Clauses Act, a private company is within the purview of the definition person. So, private company is a person. And secondly, failure to supply electricity within the stipulated time as agreed is a failure of service. So, the defense taken by the Power Supply Corporation that it is not maintainable under Consumer Protection Act as it is a commercial supply is not maintainable. The next one. A writ petition was filed by the Indian Medical Association seeking Supreme Court to declare that Consumer Protection Act does not apply to the medical profession. Indian Medical Association validated that medical professionals are governed by a separate code of ethics. Thus, medical negligence can be dealt with by medical experts in their own jurisdiction. The Consumer Protection Act should not be applied. The writ petition involved two questions as given below. So the contention of the Indian Medical Association was medical profession is being guided by a different set of ethics. So any complaint against a medical professional should not come under the purview of the Consumer Protection Act. Rather, it should be dealt with by some experts. The questions involved are whether a medical practitioner can be regarded as rendering service under the Consumer Protection Act. Question number 2, if medical services are rendered free, then would it be considered under the Act? So, first question is whether medical service is a service under the definitions given in Consumer Protection Act. This is question number 1. And question number 2 is, if the medical service is given free of cost, whether that will be regarded as a service as per the definition under Consumer Protection Act. The observation. The court held that district, state and national consumer forums can summon experts in the field of medicine. Court has immense power to summon any person, take his opinion for deciding a particular matter. Court can call experts, court can take expert opinions. So, court can summon experts in the field of medicine, examine evidence and protect the interest of consumers. Doctors and hospitals who render service without any charge would not fall within the ambit of service. If I being a consumer, I am availing this medical assistance from a medical professional or from a hospital against payment of money, then it will be considered as a service under the Consumer Protection Act. But if it is free, then it will not come under the scope, within the scope of the Consumer Protection Act. In a government hospital where services are provided free of charge, the Consumer Protection Act would not be applied. However, if customers are being provided for free to the poor, then it shall be covered as a service under the Act. in case the insurance policy company pays for the treatment on behalf of the customer, then it will be covered under the act. If I have mediclaim, I am not paying a single penny from my pocket, but on my behalf the insurance company is paying my medical bill, then I will be considered as a consumer under the Consumer Protection Act. In a hospital where medical service is provided free for the general public, that hospital or the doctor of that hospital will not come under the purview of Consumer Protection Act. But if as a policy of that hospital free medical service is given to the poor, then that poor person who is availing the service free will be considered as a consumer under the Consumer Protection Act. The next one. This is one of the landmark Consumer Protection Act cases and judgments. A student was asked to deposit a lump sum fees of rupees 18,000 something for coaching of medical entrance examination for the next 2 years. We know there are several private coaching centers who give training for various types of entrance examination: medical entrance, engineering entrance, law entrance. This amount was deposited by the student in 2 complete installments. However, the student realized that the quality of the coaching institute was not up to the mark. After payment of the entire fee and after a few days, the student realized that the quality of the coaching is not up to the mark and therefore sought a refund of the remaining period, which was further refused by the coaching institute. The student attended his classes for 1 month, and after 1 month he realized that the coaching is not up to the mark, and he stopped attending the class and asked for refund of the amount for the balance period, not for the period he attended his classes. The coaching institute refused the refund. The appellant lodged a complaint against the coaching institute before National Commission, while the coaching center submitted records that showed good results of the institute and alleged that it was wrong to observe that the coaching services are substandard. In court, the coaching center submitted results of other students, various students who did brilliant results after taking trainings from this particular coaching center, and the coaching center tried to establish that the quality of that training is not substandard at all. National Commission stated that fees once paid shall not be refunded if an unfair trade practice. National Commission stated that fees once paid shall not be refunded is an unfair trade practice. It quoted UGC guidelines declaring that even if a student has not attended a single class, an amount of rupees 1,000 can get deducted and proportionate charges for hostel fees, etc., and the balance amount could be refunded. State Consumer Forum mentioned that not just the balance amount of fee, but also the higher compensation for legal costs, as well as the pain that the student had to undertake, could be availed in such cases. The basic principle is, I am doing this video episode on Consumer Protection Act. Say 10 of you watched the entire video. 8 of them appreciated the video, got some materials from this video, and 2 disliked my video. Now the question is, those two who have disliked my video filed a case, and I am trying to substantiate that this video episode is up to the mark, because 8 out of 10 liked my video. But basically, whether my video is good or my video is bad, that depends upon, firstly, upon my capacity, secondly, the expectation of the viewer. 8 out of 10 who liked my video got some materials from my video, but it is not mandatory that as 8 liked my video, the rest 2 who disliked, they are not capable to get anything from my video. It may be that whatever I am stating in my video, they already know it, so they are expecting something better which I cannot give. They are expecting something better materials. They are in search of some better materials, so they do not like my video. But 8 out of 10 like my video. So I cannot substantiate that my video episodes are not substandard, because 8 out of 10 like my video. That cannot be a defense on my behalf. So if I am taking money from the viewers for this video and 2 of them disliked my video, I am bound to give them refund. The next one. This Consumer Protection Act case happened when a wrongful debit happened from a bank account. The complainant trust maintained an account with the respondent HDFC Bank. The bank received instructions from the Employee Provident Fund organization that mentioned order of payment of rupees 1.47 crores against the trust, and that no other payments from the trust's account be made until the Employees Provident Fund organization's liability has not been settled by the trust. However, the trust issued an instruction to the HDFC Bank not to debit any amount until further communication, as they wanted to seek a stay order. However, in payment of statutory due to EPFO, the bank, after giving due time, debit the account with an amount of rupees 1.47 crores. The challenged is this transaction as a deficiency in service and demanded the amount debited along with interest, damages, legal expenses. Trust lodged complaint against HDFC before the National Commission on the ground that bank has committed default by paying an amount payable as a statutory due. Now, what the court observed, very interesting. The National Commission dismissed the argument of the complainant, saying that the bank informed the trust as its customer and gave them due time. So it cannot be said that EPFO conducted deficiency in services. For this false litigation, National Commission had imposed a penalty of rupees 25,000 on the complainant trust to be paid to the bank. So National Commission here clearly observed that there is no deficiency on the part of the bank, deficiency in service on the part of the bank. The next one is on your screen. In this Consumer Protection Act case, a government servant had paid an initial amount for allotment of a DDA, Delhi Development Authority plot of rupees 5 lakhs in 1997. He requested for extra time to pay installments as he wanted to have a loan facility from his office. Meanwhile, he realized that the plot allotted to him through a draw of lots has already been allotted to another person 2 years ago. Due to this negligence of the DDA, the respondent approached District Forum that dismissed the case. Subsequently, the State Forum was approached that passed an order in favor of the respondent. What is that? National Commission stated that when the plot was already allotted to someone else back in 1995, the complainant made the first payment against allotment in the year 1997, and the plot was first allotted to someone else in the year 1995. That means 2 years before DDA took the payment for that particular plot from this complainant. Then why DDA took no steps for in correcting its own error in the allotment? It directed DDA to pay alternate plot of same kind or pay escalated price of rupees 30 lakhs. So the complainant first made the payment in the year 1997, and that plot which was allotted to this complainant was allotted to someone else in the year 1997. So this goes against Delhi Development Authority, and Delhi Development Authority had to pay compensation as per the order. The next one on your screen. The petitioner, who was a nurse by profession, underwent a stone removal surgery from her gallbladder but claimed that she continued to experience pain. After 9 years, it was detected that the reason behind this was that a gauge was left in her abdomen. Can you imagine? A gauge was left in her abdomen by the surgeon who operated her. This required a second surgery. Therefore, she filed the charges for negligence, and compensation of rupees 50 lakhs was demanded by the petitioner. She filed the case against the doctor for his negligence. The Supreme Court rejected the case on limitation and evidentiary grounds. The court held that when the nurse was working in the same hospital where the surgery happened, then in the past 9 years, why did not she contact the doctor? During the discovery of gauge in the abdomen, appropriate action could have been taken on an immediate basis without requiring the respondent to pay. But she chose to consume painkillers. Her long silence dismissed the complaint, and she was entitled to no compensation. Though the case is of a very serious nature, that after surgery, the doctor left one gauge in her abdomen and she suffered pain for 9 years. But Supreme Court observed that the nurse is employed in the same hospital and she had the opportunity to visit that doctor again when she had pain in her abdomen. But instead of that, he didn't meet the doctor. She didn't do anything, just she consumed painkiller. And after 9 years, she started treatment and she is claiming compensation. On this ground, her claim has been rejected on the ground of delay and limitation point. The next one, this Consumer Protection Act case arises out of a complaint of medical negligence where 20-year-old engineering student was admitted to Nizam Institute of Medical signs, in short NIMS, after he complained about the acute chest pain. After several tests and x-rays, a tumor was revealed, though it could not be diagnosed whether the tumor was malignant or not. Therefore, the patient was advised to undergo surgical removal of the same. After surgery, the patient developed paralysis. There was a complete loss of control over the lower limbs, and other related complications also raised, leading to urinary tract infection, bed sore, etc. The family of the patient held NIMS and the state of Andhra Pradesh statutorily liable, being a government hospital, liable for this utmost negligence. Family also claimed that no preoperative tests conducted, no neurosurgeon was present during the operation. Consent was only taken for tumor excision, but the doctor also removed ribs, tumor mass, and destroyed blood vessels, leading to condition of paralysis. Very interesting case. Let us see what was the court's observation. Based on evidence, Supreme Court held that a huge negligence was made out on the part of the doctors and the hospital. Why? Because they didn't bother to go for further investigation. They took no consent prior to removal of the ribs, tumor mass, and destroying blood vessels. Hence, the court awarded damages of rupees 1 crore to compensation present and prospective medical expenses and suffering of life. Due to the negligence of the doctor without doing proper diagnosis, doing the surgery, the 18-year-old boy, 20-year-old boy, had to suffer partial paralysis. On this ground, 1 crore has been awarded for this child. Today, I am ending this episode with these very important, in my opinion, very important case laws on Consumer Protection Act. If I get response and if you like, I will do further sessions on case laws on Consumer Protection Act. I will wait for your emails and texts. If you like, please subscribe this channel. Till my next video, stay blessed. Goodbye.